everyone. Thank you for joining us. My name is Jie Huang. I am a senior associate at Scott Legal PC. Today, we are going to spend some time talking about the EB-2 NIW, National Interest Waiver, which is a green card pathway that allows self-petitioning for certain individuals with advanced degrees or exceptional ability. As we will discuss in today's presentation, this could be a great option for entrepreneurs. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a month on different topics. And at the end of this webinar, we will send out a few things to all participants. So first, we will send you a copy of the PowerPoint that will be used in this webinar. Second, we will send you all a visa guide, a comprehensive guide, a document that you can use as a reference. We will also send you a link that you can follow to sign up for additional webinars that are coming up in the future. And we will send you a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe to our YouTube channel as we regularly upload immigration law-related videos. Finally, we will send you a link that you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case further. Today, we are very lucky to have Kelly Weiner, who is the managing attorney of the firm with a wealth of experience handling EB-2 NIW cases, who will be sharing her insights about how you can qualify for a green card under the EB-2 NIW category. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Kelly.
Thank you, Jie. Perfect. So let's get started just talking a bit about the National Interest Waiver requirements. So going over them in a little bit more detail. So the National Interest Waiver is available under the EB-2 category. And for this category, there is a threshold requirement that you need to meet. So first, you either need to show you have an advanced degree. This means a U.S. master's degree or higher. Or its equivalent, which would be a U.S. bachelor's degree plus 5 years of post-baccalaureate progressive work experience in the relevant profession. You can also qualify if, rather than a U.S. bachelor's degree, you have a bachelor's degree that is deemed to be equivalent to a U.S. bachelor's degree. If you don't meet this criteria with the degree, there is still an ability to apply if you can meet the exceptional ability criteria. So exceptional ability, we hear a lot in immigration law about extraordinary ability for things like the O-1A visa, O-1B, or for the EB-1A, extraordinary ability green card. So exceptional ability has a, different criteria and is easier to meet generally. Exceptional ability is defined as a degree of expertise significantly above that ordinarily encountered in the sciences, arts, or business. In contrast, extraordinary ability means a level of expertise indicating the individual is one who is of a small percentage that's arisen to the very top of their field. So with this lower standard, the EB-2 NIW can sometimes be a better option for people who maybe were targeting the EB-1A, but don't feel they have met that higher standard for the EB-1A yet. So for exceptional ability, you need to show that you meet at least 3 of the 7 criteria listed here. So, letters documenting 10 years of full-time experience, a license to practice your profession, looking at salary, membership in professional associations. And when we look at exceptional ability, there's really 2 parts to how they adjudicate these. So one is, do you meet the plain language of the regulation? So have you shown a membership in a professional association, for example? And then the second, thing that they look at is, what is the quality of the evidence? So you've met the criteria, you show you have a membership, but is that membership one where anybody in the profession can just pay a yearly fee and join as a member? Or is the membership based on kind of outstanding achievements? Do you have to have, shown a certain level of success or prestige in your field to be invited? Who else, what other types of experts or industry leaders, are they members of this association? What is the criteria for you to qualify to be a member of that association? So all of those things are what they'll consider in kind of that that second part of the test to determine if you have exceptional ability. So once you've met this threshold requirement for the EB-2, then we can turn to the National Interest Waiver part of the EB-2 process. So this is where, in the normal EB-2 process where you would go through a perm, you have a U.S. employer who's going to sponsor you for a green card. When you're applying for a national interest waiver, you're essentially saying to the government that they should waive this normal requirement of the labor market test and of having a U.S. employer sponsor you. And the way that you demonstrate that you qualify for the waiver is you have to meet these, 3 criteria that are outlined here. So one is you have to show that you are going to engage in a proposed endeavor that has both substantial merit and national importance. So, this is where, what the project you're going to be working on, what you're actually going to be doing in the U.S., whether that's as an individual, if you're self-petitioning, or for an employer, if you have an employer who's sponsoring you. So you really need to dig into, what is it that you're going to be doing? What is your field? Why does it have national importance to the U.S.? Is it something where you're going to increase the U.S. competitiveness in a particular area? There's a list of kind of critical emerging technologies that the government has flagged as really key. Is your endeavor in that area? What is it that you'll actually be doing in the U.S. and how can you demonstrate substantial merit and national importance? And later in the presentation, we'll talk a bit more about the specifics of how to do that. So the second criteria is that you yourself, the applicant, are well positioned to advance the proposed endeavor. So for example, even if they agree that, the endeavor that you're working on is very important, the other piece is that you need to show that you have the ability to advance this endeavor. So what is your background? What is your work history? Have you, participated in similar endeavors in the past and been able to bring them to, a successful fruition? Have you had a similar company and perhaps you sold it, or been a project leader in the past on similar types of things like that. So it's not required that you show that. You don't have to show that you absolutely will succeed or that you have in the past done the exact same endeavor, but it certainly is helpful if you can show that. And if you're not able to show that, you should be able to show, similar prestige in your field such that the government would feel comfortable that you would have the ability to advance this particular endeavor. And then finally, the third criteria is there has to be a showing on balance that it's beneficial to the U.S. to waive the requirements of the job offer and thus the labor certification, which is that normal labor market test we talked about. So, particularly as we'll talk a little bit more about in the next slide for entrepreneurs, for example, you can demonstrate that entrepreneurs are really not able to go through the normal labor certification process. If they are, a majority owner of a company or even, own a substantial piece of that company, the labor certification process is generally not set up for them to be successful in that process. Additionally, you can demonstrate that the urgency of what you're working on is, it's so important, it's so critical, it's so urgent to the U.S. that even if there are, other people in the United States working on it, it's still beneficial for you, to be here working on it. So let's talk a little bit more about how the National Interest Waiver can be used for entrepreneurs. Prior to 2017, the National Interest Waiver was not really thought of, for entrepreneurs as much. However, there was a change in the adjudication standards with a new case called Matter of Danazar. And in that case, they made it very clear that they do interpret, this criteria for the EB-2 NIW to be used for entrepreneurs. And they provided some really helpful kind of examples and some changes in adjudication standards to be used for entrepreneurs. So let's look at a few of those here. So one is that when we're talking about, substantial merit and national importance, they explain that the benefit to the U.S. interest can be local. Previously, perhaps they focused on national importance as something that needed to be, like a large geographic scope to have national importance. And, a change here was they really focus instead on a local, a local change. So for example, hiring lots of employees in an economically depressed area, that is something that could be said to have national importance, even if it's only impacting this one particular area and not impacting the entire United States. So that was really I think a helpful, kind of clarification that they made and a change that they made, to to demonstrate that this is one way job creation in an economically depressed area is one way entrepreneurs could make this national importance argument. Another thing they mentioned is, the fact that entrepreneurs are self-employed. They are not eligible generally for green cards under the labor certification requirements. When you do a labor certification, you have to disclose if there's any ownership, in the company on the part of the applicant. And if the applicant is a major owner of the company or holds substantial interest in the company, it's very unlikely the government will be convinced that there's really a bona fide job opportunity open to a U.S. worker, as opposed to, the company, going through the process, but favoring the owner. So because of the fact that it's essentially, impossible and, at minimum impractical for an entrepreneur to gain a green card through the labor certification process, this is, one argument that you can use for that third prong to explain why, on balance, it's beneficial to waive this requirement. Finally, Danazar specifically noted that entrepreneurial work can lead to a national interest waiver. And importantly, they pointed out that the planned venture does not have to ultimately succeed, as long as the applicant can show it's more likely than not that it will succeed. So they really are allowing here for kind of startups, companies that are in earlier stages that have not yet achieved necessarily all that they are going to set out to achieve. So the idea that you could submit a business plan, you can submit proof of contracts, proof of, plans in the future, and those things would be sufficient to qualify for an EB-2 NIW. So you don't have to apply with a company that's already successful. You could apply with a brand new venture. And this was something that was really helpful as well in Danazar, to show how the national interest waiver, should be used for entrepreneurs. Let's look a little bit at some logistics regarding timing, and considerations when perhaps you're here on a non-immigrant visa and now you want to move, to a national interest waiver, to a green card. So let's look at timing. Favorable changes, in the last year. Our premium processing is now available for national interest waiver applications. This means that you can submit an additional fee to the government and they will issue a decision, which might be an approval, a denial, a request for evidence, or notice of intent to deny within 45 days. If you choose not to go with premium processing, it could be that your case is pending for over a year or more. So, it's definitely a great benefit that you can now apply for premium processing, as prior to this, really everyone was just kind of in a holding pattern waiting for, for a decision. If you're on a non-immigrant visa, you want to look at what type of non-immigrant visa you're on and, what the requirements are for intent. So for example, for the TN, for the e-visas, these are visas that do not specifically allow for dual intent. You have to show for the TN, for example, that you have a foreign residence you don't intend to abandon. For the E1 and the E2, it's a little bit lower of a standard, but you still need to show an intent to depart the United States. So once you filed an I-140, which is an immigrant visa petition saying you want to permanently remain in the U.S., there can be some issues with renewing, these types of visas, particularly a TN, where there's a very high standard for non-immigrant intent. So if you are on this type of visa, you want to think strategically about when to submit your I-140 petition. For example, the TN can be granted for 3 years. If you're needing to renew in the near future, perhaps you want to renew first, get an additional 3 years, and then go ahead and file your I-140. So you're not in a position of having to explain to an officer, why it is that you don't have, immigrant intent on this particular visit. It is true that intent is supposed to be assessed at each entry. So if at that point in time you say, well, yes, I have an I-140, but I don't intend to adjust at this point, I've filed it to keep my options open for the future, you could try to make that argument, but, some officers may not be persuaded by it, particularly for the TN with such a high standard for non-immigrant intent. So it would be much better to plan the timing of your immigrant visa petition filing so that it's not being filed, right before you have to renew, a non-immigrant visa that doesn't allow for dual intent. If you are on an H-1B or an L, these visas do specifically allow for dual intent, so less, not a concern about the timing for filing if you're on one of those visas. So in terms of the application process, you submit Form I-140 with proof that you meet all the EB-2 qualifications. So those are all the documents we talked about. If you're qualifying based on an advanced degree, you'd submit your degree. Exceptional ability, you'd submit proof of that. And then you need to submit proof of your endeavor, proof that you are well positioned to advance the endeavor, and an explanation of why it's, beneficial to waive the labor certification. And later in the presentation, GA will go over in more detail exactly what's going to be submitted, with that I-140. If there's an immigrant visa available in the EB-2 category and you're in the US in a valid status, you could also go ahead and file your green card application on form I-485. The other option is to consular process. So that's where you would actually go abroad to the US consulate in the country where you previously lived prior to coming to the US, and you would get your green card at that consulate. So let's talk a little bit more about those two options. Is the category current? Unfortunately, right now, the EB2 category and EB3 category are backlogged. It is likely we'll continue to see some level of backlog for the foreseeable future. So that means that, for example, this month in November of 2023, I believe for EB2s, your priority date needs to be prior to January 1st, 2023. And if it is, then you're able to go ahead and file your green card application if you're in the US in a valid status. And if not, you're still waiting. So if the category is current, your green card process will proceed. If the category is not current, then you're going to be waiting, for a while until it becomes current, and then you'll be able to proceed with the application. It is important to note that just having an approved I-140 does not give you any underlying status. So it's not a situation where you can rely on that to stay in the US. You would need to either have some different non-immigrant visa status if you wanted to stay, or once you get to the point where you could file the I-485, a pending I-485 will also allow you to stay in the US. But just that I-140 approval does not give you any status. Let's talk about the pros and cons of adjusting status versus consular processing. So an adjustment of status, generally you're going to do this if you're someone who lives in the United States, your family lives in the United States, you work here, your kids go to school here, this is where your primary residence is, then most of the time an adjustment of status is going to be the option for you. The benefits of it are that, once you file it, you're permitted to stay in the US, in an authorized period of stay until the I-485 is adjudicated. Additionally, you and your spouse and dependent children can also apply for work and travel authorization along with the I-485 green card application. So if staying in the U.S. is kind of the main goal, then an I-485 is generally going to be the route that you take. For consular processing, you may be in a position where perhaps, you had an underlying status, but maybe it lapsed. Maybe there's a delay in being able to file for the green card and you're not able to stay in the US. You would depart the United States and you would get your green card at the US consulate abroad. Additionally, if you're in a situation where you have to travel all the time, and you're not on an H-1B and you're not on an L, when you file for your I-485, you file for work and travel authorization. That travel authorization and the work authorization can both take months to be approved, sometimes even up to and over a year for these travel authorizations. If you're in a situation where you have to be traveling a lot for work, it may be the case that it's better for you to apply through the consulate, and continue to travel on your non-immigrant visa, and proceed with your green card process at the consulate. So it is an important thing to kind of discuss with your attorney to decide what is going to be the best option for you, and like what's going to meet your needs, especially as both the I-485 and the consular processing are usually timelines are usually up to and over a year. So it's something where you really want to be planning out for the future as to what's going to work best for you. All right, so I'm going to turn it over to GA to talk about some updated guidelines that were quite favorable for both entrepreneurs and STEM applicants.
Sure. Okay, so we can talk about those. In the beginning of 2022, we saw some announcements that made it favorable for certain STEM applicants and entrepreneur applicants in pursuing the NIW category. So let's look at STEM first. So one important update that was made was that the government announced what is called a Critical and Emerging Technology List, CNET list. And if your endeavor, if the applicant's endeavor is related to advancing those critical and emerging technologies and advancing U.S. competence in those technologies, then it will be very favorable for NIW applications. So I will read out what those technologies include. So this includes areas like advanced computing, advanced weapons technology, advanced engineering materials, advanced manufacturing, advanced sensing technologies, aero engine technologies, agricultural technologies, artificial intelligence, AI technologies, autonomous systems technologies, biotechnologies, communications and networking technologies such as 5G networks, for example, and Internet of Things, data science and storage technologies, distributed ledger technologies, energy technologies, medical and public health related technologies, quantum science, semiconductors, and space related technologies. So you can see that the government is really interested in really maintaining the US's cutting edge leadership in those critical industries for the future. So another update that is important to note is that if an applicant has a PhD degree or just any master's degree or above in a relevant STEM area, such as the CNET area, and if their proposed endeavor is to do research or anything like that, or R&D, to advance CNET STEM technologies, the government says that this can be a very strong positive factor to meet the third prong, which is on balance, it'll be beneficial to the United States to exempt the labor certification requirement for that particular applicant. So now let's look at the entrepreneur-specific guidelines that were announced. So what is important to note here is that now entrepreneurs can prove well-positioned and national importance through non-traditional forms of evidence. So for example, substantial merit or national importance can be supported by submitting such as media attention on the business itself, even if the applicant himself or herself is not mentioned in the media article, awards or grants from government entities. And interestingly, letters from relevant industry organizations such as venture capital firms can also serve as a form of support for the merit and national importance of your business project. And other evidence such as proof of incubator admission. So if the particular startup has earned admission to a prestigious incubator accelerator program such as Techstars or Y Combinator or things like that, that could be a very positive factor for substantial merit, national importance, and well-positioned for such an application. Proof of investment can also help, especially if those investments are by third-party objective institutions that typically are in the business of evaluating such business plans and can serve as independent validation of the industry disruptive potential of such an endeavor. Proof of having received government grants or funding for the project can also be very positive. There are also other forms of evidence that can support well-positioned, that the individual is well-positioned to advance the endeavor. And one thing to note is a history of revenue growth and job creation can really be a positive factor to support the well-positioned prong. So if an applicant has been running the company as the CEO in the United States on an E-2 visa, for example, for many years, and if the trajectory of the company's growth can be shown through tax returns, industry valuation reports, for example, a record of hiring through W-2 records, for example, that can show significant levels of hiring that grows over the past few years. That could also be a very helpful factor for supporting well-positioned. Finally, another thing to mention is contracts with leading industry actors can also be a very positive addition to your file to support well-positioned, showing that the industry is already interested in your services or products, and you can show ongoing interest from U.S. actors on your offerings. All right, so we can move on to the next slide. So now then, let's talk a little bit about what is included in an NIW submission. So I will talk a little bit about what kinds of documents and supporting evidence that we would typically collect and submit for the NIW. So first, the first part of an NIW petition is you need to show proof that you meet the threshold requirement for the EB-2 category in general. So as Kelly mentioned earlier, this can be met in two ways, either by proving that you have an advanced degree or equivalent, or by showing that you have exceptional ability in your field. And how do you show that you have an advanced degree or equivalent? You would show a copy of your diploma or transcript. Usually we submit both a transcript and a diploma for your PhD degree, master's degree, for the degree that is considered a master's degree or higher. And if it's a US degree, you can just submit the diploma in the transcript. If it is a foreign degree, a degree that you got from a foreign institution outside of the United States, we would also have the client obtain a US education equivalency report to confirm that the foreign degree is actually equivalent to the level of degree that is required for US standards. Now, there's another way, even if you don't have a master's degree or higher, if you have a bachelor's degree and 5 or more years of progressive work experience in your field after your bachelor's, you can also be considered as an equivalent of an advanced degree professional. So in order to prove that, similarly, we would submit evidence of your bachelor's degree through submitting your diploma and transcript. And if it's a foreign bachelor's degree, you would also get the US degree evaluation, equivalency evaluation. And you would also provide employer letters that show that you have 5 or more years of progressive work experience. And in those employer letters, you would really go into detail about how your duties change in complexity, increase in complexity and seniority over time to meet the progressive work experience requirement. If your duties has just stayed the same over 5 years, then unfortunately that will not be sufficient to meet the progressive work experience requirement. Now, let's shifting gears. If you're meeting the threshold, EB-2 threshold through showing exceptional ability, then you would also collect evidence that shows that you meet the evidentiary criteria of exceptional ability. And also that shows that you are operating at a level that is significantly above that is ordinarily encountered in your field. So for example, if you're meeting the evidentiary criteria of 10 years of work experience, you would similarly, similar to what I just shared earlier, you would contact your past employers and have those employers, usually it'll be your supervisor, write a letter on the company's letterhead, describing the period of work and the duties that you served in that position prior to previously. So you would collect those evidences and prove that you actually have worked 10 years or more in your field. If you're, showing licenses, for example, you would submit copies of those licenses. If you're also meeting the membership criterion, you would get either a certificate of membership from the particular organization or any other proof, reliable proof that shows that you do have the membership and you are a member of good standing of that particular organization. Finally, for recognition for original contributions, that could be shown through submitting expert letters that talk about your contributions in the field. If you have authored patents in your field, for example, we would submit copies of those patents. If you've made any, publications in journal articles, professional or academic journals in your field, we would submit copies of those publications as well. If you have won any awards in your field, we would also submit copies of those awards and confirmation that shows your name. That the USCIS can look at and really understand that you have indeed won those awards and what kind of award it is. Now, so if you prove, after you prove that you meet the threshold requirement for the EB-2 category in general, the rest of the petition package would really be evidence that is supporting the 3 prongs that we talked about of meriting a national interest waiver. And the 3 prongs, as a reminder, are national importance, well-positioned, and on balance, it is beneficial to the United States to exempt the labor certification requirement for that particular case, right? So for national importance, one common type of evidence is objective news articles, academic papers, and other evidence that shows why a certain area that you're active in is an area that it is important for the United States in terms of, a U.S. policy priority, such as if you're, developing some technology that makes manufacturing processes more sustainable, environmentally friendly, for example. We would collect evidence such as government announcements, executive orders, and evidence of government investment in technologies for environmental sustainability to really show why the US government will care about the particular initiatives that you are pursuing with your business. A business plan is also highly recommended for entrepreneurs to prepare for an NIW petition, because that can show what are the prospective impacts of your business, prospective impacts of your project in the United States in terms of revenue generation, generation of tax revenues, for example, and also US hiring. So if you can show that your business project has the potential to hire significant numbers of US employees, that can also be a powerful support for your case in arguing national importance. So a business plan plays an important role in that as well. Now let's talk about expert letters. Expert letters in an NIW petition play the role of really building out the narrative of why your work is important and why the work serves US government priorities and what kind of broad impact that we can expect from your work, such that we can properly consider that your work will have national importance. In another function that the expert letters can serve is to support the second prong, well-positioned, that you as an individual have the right skills, have the right experience to really drive the project to success. So in those expert letters, in some of the expert letters, it will be important to describe that you have a record of success, and really to build out this record of success with many case studies, for example, that shows what have you done in the past and what was the impact of that work in your field in the past that can, support the conclusion that your present projects will also likely be successful. Another part of well-positioned is to show, and as I mentioned, in addition to expert letters, you would want to add some objective forms of evidence of the applicant's own experience and skills, such as relevant education. So as we mentioned before, we would typically include copies of degrees. We would also include a copy of the applicant's resume that lays out all of these different experiences that they have accumulated throughout their career, and proof of some professional accomplishments. And this can be in various forms. Sometimes the applicant is interviewed in industry media for their achievements in the field. Sometimes the applicant's work has resulted in the publication of patents. Sometimes the applicant's work is featured in an industry podcast or things like that. So we would collect all of those corroborating evidences, and combined with the expert letters, that can really serve as a powerful supporting evidence to really show that your work has had an impact in the field and that you do have an outstanding level, a unique expertise, skills, and knowledge that could position you well to drive the project to success in the United States. Now, another quick note on entrepreneurs. One type of evidence that we encourage entrepreneurs to provide is contracts with leading industry actors for to show ongoing interest in their work. Letters of intent can also be helpful, especially if the letters of intent come from prestigious industry leaders in your field, or even government entities. So for example, if you are active in the agricultural field, and if you can get a letter of intent to collaborate with a government agency that covers the field, such as the USDA, that could be a very powerful form of evidence for the NIW to support the merits of your case. And the startup capital. Startup capital is also one aspect that can strengthen your case. If you have signed an investment agreement with a venture capital firm, for example, you can include the share purchase agreement, or even a letter of intent from that incubator accelerator to show that you will get that funding to really provide runway for your startup project to succeed. All right, so we will move on then, shift gears and talk about a case study. that can provide an example of a national interest waiver applicant who met each of the NIW criteria. So this case was for an entrepreneur who formed a small consulting firm to work on projects focused on improving services to U.S. veterans, right? So let's look at the three categories and how the applicant met the three categories, the three criteria for the NIW. So first, for substantial merit and national importance, as I mentioned, the proposed endeavor was to operate a small consulting firm in the United States focused on coordinating relevant organizations and projects aiming to facilitate the reintegration of returning veterans and wounded warriors back into productive society. So connecting productive, job opportunities with wounded warriors who may have some talents. So this person provided a business plan that included letters from prospective clients and really describing how this work will improve upon currently available services for wounded veterans, really talking about the gap in those services that the industry had and how this person's services will really fill this gap and really end up improving the welfare of veterans and really facilitate their work, facilitating their recovery and reintegration into productive society. Another type of evidence that really helped in this case was submitting government reports, news articles, letters from senior officers in relevant organizations in the United States, really describing what are these gaps in veteran care and showing that significant public interest is involved in this work, really showing that veterans' welfare is a priority for the U.S. government. There were a variety of objective third-party reports that supported this, which helped prove the substantial merit and national importance of this person's proposed endeavor. Now then, let's move on to the second prong, proving that an individual is well-positioned to advance the proposed endeavor. So in this case, the applicant had a very remarkable success record in past endeavors in the UK, which is where he was from. And to support this person was able to get expert letters from very senior officials from government in the UK who had worked with him in the past. Specifically, this person had played a leading role in developing and implementing initiatives to connect public organizations and nonprofit organizations in the UK. And according to some of these testimonials, this person's efforts have really made a difference in hundreds of veterans' lives, giving them opportunity to really reimagine their lives. And also, and the scale of these efforts were large, productively connecting millions of dollars of charitable funding to these relevant veterans welfare projects. So those case studies that were, really explained by these expert letters played a big role in supporting that this person was well positioned to continue doing this work in the United States, really groundbreaking work in this area. Another type of evidence that was helpful in this case was that potential clients and potential collaborators for this business submitted letters of intent and contracts to prove that there was sufficient demand for this person's work in the United States. And also in the business plan, the applicant submitted financial statements showing that there was sufficient startup capital to really provide runway for this project. Now then, moving on to the third prong, on balance, beneficial to the United States to waive the labor certification requirement. So some of the arguments that worked well in this case was that this applicant, being an entrepreneur, will be self-employed, so that it will be impractical to obtain a labor certification and to engage in the traditional perm process to get a green card through employer sponsorship. So that was one argument that worked well. Another argument that was made was really on the immense value, the broad value in improving programs with regards to veterans' welfare and assisting organizations really to advance the public interest of, helping this group of people really access better care and transform their lives. Finally, one thing the government also noted was a past record of success that really showed that this individual had an outstanding level of knowledge and unique skills that could not easily be replicated by just somebody else in the United States with similar credentials. So based on these facts, the government was able to find that the U.S. would benefit from this particular person's contributions, even if other qualified U.S. workers were available to perform these functions at a minimum level. All right, so I believe that is all of the contents that we had, and we can turn to questions and answers. So we have one question, I believe, is a business plan required for STEM? And for that question, I think it will really depend on what is your proposed endeavor, right? So if you are someone who is a STEM researcher, and if your proposed endeavor is to perform research in industry or academic settings, then maybe a business plan is not required because your proposed endeavor will not involve business-related management or entrepreneurship. However, if you're an entrepreneur and if as a part of your business, if you're developing STEM technology in the industry and developing a new product or service, for example, maybe a business plan would be helpful. So this would definitely depend on the individual facts of the case.
All right. It doesn't look like we have any further questions, so we will close there. Thank you, everyone, for your participation. Thank you, GA, for sharing your knowledge. I hope everyone has a wonderful day. Thank you.
Thank you.